Now, my lord.
Yes.
Permission, I want to mention a case.
Yes.
It is a tied up matter CRMP case number
Mr.
20
Counsel, you don't know the procedure of this court? Have you not gone through the list?
out of list, Lordship.
You don't know what is the system of mentioning out of list before this court? Everyone, the entire court knows. Are you an alien?
Sorry, Lord.
Malad, from the list, may I mention a case to your lordship?
Yes.
Malad, item number 25 and 26. I've
Item
taken
number 25 with item number 26.
Malad, let it be taken in the next week, your lordship. I'm having some personal difficulty, Malad.
Yes, Mr. Arvind Lal.
Yes, my lord.
On the request of Mr. Alok Lal, let this case these two cases be listed after 1 week.
My lord.
Any more mentioning from the list? Yes, call the list.
From daily corporate, under heading orders will detect figure number 1.
May I mention, may I mention, Lord, CM number 37, your lordship. My name is appear on top of the railway side, your lordship. I am not at the council of the
Let it be called out. Matters have already been
respondent,
called
your lordship.
out. Right. I had given you time. Let the matters be called out now.
Lordship.
Who is in this case?
May I please lordship?
My name is in list, your lordship, serial number 37, your lordship.
We have
Although
already.
the council of the railway panel is Vijay Kumar Sinha, your lordship. But the cause list, your lordship, my name is appear on behalf of the railway side, your lordship. Vijay Kumar Sarma, your lordship. So kindly name may be deleted, your lordship.
Yes. Next. Yes. Who is appearing in this case?
In this case, my lord, I am for the number 2 under the instruction of Mr. Yasir Arafat.
Mahesh Tiwari, Rahul Dev, Suresh Prakash.
May I please lordship? Sorry, I got disconnected, my lord. I'm extremely
Yes.
sorry.
Yes.
My lord, this matter, although this has come under orders with defect, my lord, but on previous occasion, my lord, notices were issued in this matter. And for respondent, wakalatnama has also been filed, my lord.
Respondent number 1 has appeared. Respondent number 2 has also appeared.
Yes, my lord.
My lord.
Take down. Respondent number 1 and 2 have appeared in this appeal. Full stop. Next line.
Number 3 is also there, my lord.
Notice upon respondent number 3 has been validly served. Full stop. Yes. What is this appeal
This
about?
matter, my lord, it has been filed for challenging the award by which half of the compensation has been.
You have not filed a certified copy of the judgment of MSCT? You have filed.
My lord, my apologies, my lord. Today itself, I got the file. I was just going through it, and I was not aware about the fact that what are the defects, my lord. If there is a subsisting defect, my lord, I undertake to remove this, my lord.
Just a minute.
My lord, the award has been challenged, my lord, as the appellant has been directed to make a payment of half of the compensation, my lord. And reason assigned is that he was not having a proper route permit, my lord. But what is very important, my lord, in this case, from the same incident, my lord, 2 MSCT case were filed.
Just a minute.
Sorry.
Defect number 1 has been removed. Defect number 2, the office still says the defect number 2 has not yet been removed. Defects pointed out by further SR 6419. Okay. 6419. Address details of the sole petitioner. Remove. Counsel for the appellant. By what time you will remove the defects?
Within 1 week, my lord. Within 1 week.
Undertakes to remove the defect within undertakes to remove the defect, comma, as pointed out by the office note dated 6/4/2019, within a comma within a week. List this case after removal of the defect under the heading for admission.
DP of that, my lord.
I am for the state, Your Lordship.
Under the heading for order, serial number 2, MA number 66 of 15.
My lord, my lord,
Yes.
my lord,
Further 1 week time may be allowed. Let's say there was a direction to file the rejoinder, but it could not be filed due to the sharp rise in the COVID, Lordship. Now everything is ready.
Mr. Pankaj, learned advocate Mr. Pankaj Chaudhary prays for 2 weeks time to comply the earlier order dated 10/1/2022. They are allowed to list this case after 2 weeks.
my lord, may I say only one thing?
Yes, yes,
This
yes.
this is a very one thing only, my lord. Very short matter, my lord. Eviction suit. I am the landlord appellate. Suit was decreed. On the basis that there is admission on the part of the defendant tenant that he is a tenant, my lord, on the basis of registered document, registered deed. Now, thereafter, in the appeal, appellate court has remanded the matter back, directing the trial court to decide issue of title. So this is admitted appeal, my lord. During dependency, they have started new construction. That's why we have filed an
No,
IA
Lordship.
for
As per
injunction. Now,
Are you-
wait, my dear friend, just a moment, just a moment.
Mr. Verma, Mr. Verma, are you pressing this IA?
My lord, what I am submitting, my lord?
Just tell me one thing. If you are pressing this IA, he is praying for some time to file a rejoinder. He admits the time was given earlier, but because of COVID, he couldn't
My
file
lord, my
this
lord.
plan.
My lord.
Now, I cannot pass any order in this IA 7 except an order for dismissal without giving him an opportunity of filing any application, a rejoinder.
My-
What do you
my
want?
lord.
Tell me. You want
No,
disposal of this IA? Dismissing it?
My lord, this matter may be.
He has to be given an opportunity to rebut what you have
Yes,
stated
yes,
there.
yes.
2 weeks.
Obliged, Lordship.
Is this case under the same heading thereafter?
Serial number 3, MA number 210 of 15. Mr. DC Ghosh for the appellant, Mr. Jayant Kumar Pandey for the respondent.
My lord.
There is a limitation of 20 days.
Yes, who is the respondent?
It's not regarding my lord that whether there is any office.
It's for limitation. Who appears? Who appears? No one appears on behalf of the respondents to oppose the application filed under Section 5 of the Limitation Act, wherein prayer has been made to condone the delay. Next para. Yes, Mr. Ghosh.
Well, regarding 2021 days delay.
Uh,
On para 2-3. This is.
There's a delay of 20 days in filing this appeal. The counsel appearing on behalf of the appellant submits that the reasons have been mentioned in paragraph 4 to paragraph 6 of this IA. He submits that the delay was not intentional and because of some unforeseen reasons, the delay was caused. Next, but I've heard the counsel for the appellant and I've gone through the petition. First of all, after perusing paragraph 4 to 6, I find that sufficient ground has been shown to condone the delay. The delay is condoned. Is this case full stop? List this case under the heading for next line for admission.
One.
IA disposed of.
Serial number 4, MA number 266 of 15, Mr. Arvind Kumar Lal for the appellant.
My lord, in this case, earlier, my lord, the notices were issued to the respondents. I am not aware whether it has been validly served or not.
Fresh steps, ordinary process,
My lord.
visits 3 weeks. Upon
In this case, my
respondent.
lord, since United India Insurance Company is also a party, may I serve two set of copies to any learned lawyer?
The appellant will serve 2 copies of this memo of appeal upon respondent number 3. Notice to respondent number 1 and 2, service service of 2 copies upon the counsel appearing on behalf of respondent number 3.
My lord, my lord.
सर दे दीजिएगा कॉपी भिजवा देंगे.
हाँ ठीक.
Serial number 5, MA number 283 of 15, Mr. DC Ghosh for the appellant.
My lord.
In this case, I am for the respondent, claimant.
Yes, Mr. Ghosh, you have not complied the order dated 27/10/2021. Draft.
Application. My lord, as a last chance, my lord, 1 week time may be given to comply with my last order, my lord.
I'm giving you 3 weeks.
My lord.
3 weeks. 3 weeks time granted by way of comma, by way of last indulgence, comma, to comply the order dated 27/10/2021.
My lord.
Serial number 6, MA number 304 of 15, Mr. Ashutosh for the appellant.
Made to Your Worship, earlier notices were issued upon the respondents, and subsequently I could not check the office note, my lords.
Fresh notice upon respondent number 128 by ordinary process. Requisites 3 weeks.
Serial number 7, MA number 337 of 15, Mr. DC Ghosh for the appellant, Mr. S.K. Nayak.
Earlier notices were issued, my lord.
Notices received to whom?
Fresh notices were issued upon the R6, respondent 6. My lord, thereafter the office note, my lord,
Who is R6?
respondent. Yes.
Who is R6?
Yes, my lord. Yes.
Owner of the vehicle.
Owner of the vehicle. And the amount deposited only for right of recovery. Owner of the vehicle.
This is a right of recovery.
Only for right of recovery.
No, my lord, recovery right has not been given, but in the appeal, my lord, there.
No, they are prayed for right of recovery in this appeal. That means they are at best the highest
Perhaps
highest achievement would be to get a right of recovery.
Yes, ma'am.
My lord.
Have you satisfied the award?
15 lakhs, perhaps they have claimants have withdrawn. And regarding the rest amount, that is lying before the court below, perhaps 3 or 5 lakhs.
My lord, order dated 26th of April 2018, may kindly be seen. 26th of April 2018.
Are you challenging the quantum, Mr. Ghosh? No.
My lord,
Just tell me. Have you challenged the quantum?
yes, just no, my lord, no. Only for right of
Okay.
recovery.
Issue notice by registered post to respondent number 6, requisites 2 weeks. Full stop. Next para. The quantum has not been challenged. Full stop. From the submission made by the parties, this court would gather, it is gathered that at best a right of recovery can be granted in favor of the insurance company, to recover the amount from the owner of the vehicle, if this appeal succeeds. Also, next part. Considering the aforesaid fact, opposite position, the order dated, the appellants, the claimants, if so advised, may file an application for withdrawal of the balance amount which is lying with the tribunal.
My lord, perhaps the claimants, हम पहले एप्लीकेशन फाइल किए थे कि क्लेमेंट नंबर 1 पर ये करने के लिए शायद 5-6 क्लेमेंट्स था, तो दिक्कत हो रही थी उन लोग को विथड्रॉ करने के लिए. इफ मिस्टर लायक सबमिट्स, तो किस पर दिया जाएगा, क्लैरिफाई कर दिया जाए.
No. That order has been modified, my lord. 26th of July 2019. Subsequently, that order has been modified.
Well,
Yes, you get the benefit of the award.
Yes.
Yes, next.
Serial number 8, MA number 388 of 15, Mr. PC Jha for the appellant. Notice for R3 is not filed.
Mr. Jha, you have not filed the notice upon respondent number the requisites for service of notice upon R3. Yes, Mr. Jha. You have not filed the requisites for service of notice upon respondent number 3. There's some problem with your microphone, I think. Yes. You log out, then again log in.
Yes, Lordship. I am audible?
Yes.
Yes,
You have not filed the
yes.
You have not filed
Yes, it is purely mistake on my part, Your Lordship, because of some
How much time?
only
How much
7
time?
days. Only 7 days. Within 7 days.
1 week time is granted to the appellants to file requisites so that notice can be issued upon respondent number 2.
Yes, Lordship.
In
My
terms of the
Lordship.
earlier,
My
terms of the
Lordship.
earlier order. In terms of the earlier order.
Oh, right, Lordship.
Serial number 9, MA number 391 of 15, Mr. C.S. Singh, Mr. C.G. Chaudhary for the appellant, Mr.
On the last occasion, your lordship was pleased to issue fresh notice to respondent number 2, and fresh notice was thereafter I take steps, and perhaps respondent number 2 appeared, my lords.
Yes, who is appearing for respondent number 2? Anyone appearing on respondent number 2? Who are for the respondents? Any name? Anyone appearing?
I am for respondent number 1, my lords. For Intel Insurance Company.
And who is for respondent number 2?
Respondent number 2 was the owner of Tata. Both, my lords.
The vehicle.
And on last,
Owner of the vehicle.
owner of the vehicle, Tata.
No one is appearing. The notice has also not been. I think it is.
I've taken steps on 16/12/2019.
No. Last order was 13/12/2021. Fresh notice was directed to be served, my lords, upon respondent number 2.
What is the name of respondent number 2?
Name is, my lords.
Name is my lord, Sanjeev Kumar Singh.
Sanjeev Kumar Singh. And I am for 3, my lords. I only have stated 1. I am for 3.
Yes, yes. I am on behalf of respondent number 1.
The service report in relation to the notice issued to respondent number 2 has been placed before this court. From the report, I find that the process server has intimated that he went to the house of the respondent number 2 and tried to serve the notice. Full stop. The respondent number 2, after seeing the notice, refused to receive the same. Full stop. Next para. In view of the report, the notice is validly served upon respondent number 2. Next para. IN number
that is
4593 of 2015.
my lord.
There's a delay of 56 days in filing this appeal. Yes, what do you have to say?
My lord, so far delay is concerned, my lord, actually after accident he was 50% invalid and treatment was going on in Delhi and therefore the delay was there. Para 2 I have mentioned it, my lord.
As per the counsel for the appellant submits that after the accident the appellant was under treatment. As such, she couldn't file the appeal within time. Full stop. The counsel appearing on behalf of the insurance company, what do you have to say?
Your Lordship, I am opposing, Your Lordship, only formal opposition.
So, what do I dictate in the order sheet?
Your Lordship is not admitted in the from the judgment. It has come. Your Lordship is not admitted in Delhi. Your Lordship, go and after treatment he come to the Ranchi. Your Lordship.
The counsel for the insurance company submits that there is nothing on record to suggest that he got admitted in New Delhi for his treatment, but rather he used to visit for his treatment. Considering the submissions and after going through the record, I am inclined to allow this IA as sufficient ground has been shown to condone the delay. Full stop. The delay of 56 days is hereby condoned. IA allowed the case under the hearing for admission.
Public.
Serial number 10, MA number 416 of 15, Mr. Manish Kumar for the appellant, Mr. BC Jha.
I had taken time for filing petition for substitution, my lords. I could not file, my lords. 1 week time you kindly be given, my lords.
Who am I to give you time to file a petition for substitution? If you don't file within time, your case will stand abated. The appeal will stand abated.
My lords, I have come to know only after the respondents have filed the IA, my lords, only one indulgence.
That is your ground to condone the delay and setting aside abatement if any.
I'll explain the delay, my lords. One more indulgence may be granted, my lords. Only 1 week chance, my lords. 1 week time.
After the appellant pays for some time, prayer allowed this case after 2 weeks.
Obliged.
Serial number 11, MA number 503 of 15, Mr. Alok Lal for the appellant, Mr. Amit Kumar Chaudhary, Kumar Nishan, Mr. Abhay Kumar Chaturvedi, Mr. Ramesh Kumar Singh, Mr. Hadi Ansari for the respondents.
My lord, in this case, on the last occasion, the order was passed for await for the service report of respondent 1, 4, and 5. I'm not know, however, what is the status?
I am appearing on behalf of respondent number 1, Lordship.
So far as 4 and 5?
Several names are appearing, Your Lordship.
Respondent number 1 has appeared.
1 and 2, Lordship, because both are the same person. He
1
is
and
the
2
owner.
1 and 2 has appeared. So far as respondent number 4 is concerned, the notice has been received by respondent number 4. Full stop. The notice issued to respondent number 5 has been received by his daughter-in-law. Full stop. The notices are validly served. Who is 3?
He is.
If you are appearing on behalf of 1 and who is 3?
Minor. Minor daughter of respondent 1 and 2.
You are appearing on behalf of respondent number 3 also. Mr. Rajesh Singh.
Yes, Lordship.
What about 3? Who is a minor?
Pushpa Kumari.
Represented by respondent number 2.
I will take she is daughter of the respondent number 1.
Next line, Mr. Rajesh Singh, advocate, learned advocate, submits that he will he will ensure appearance of respondent number 3 through her natural guardian. Full stop. Next.
No,
Next
Lordship. Respondent number 3 is the son of late Bandhanu Sahu.
As 503, she is the daughter of
Yes, you are arguing.
Nirmal Sahu.
Serial
Pushpa
number?
Kumari.
Mr. Rajesh, serial number?
11, Lordship.
Serial number 11.
11 कहाँ इसमें है?
We are in serial number?
Serial number 11,
Yes.
Lordship.
Who is respondent number 3? See your brief. She is
The daughter of the deceased, represented by her mother.
Is that the daughter of respondent number 1? You are appearing on behalf of respondent number 1.
Yes, Lordship. Yes,
He is
Lordship.
also the son.
Petitioner, respondent number is the owner of the vehicle, Lordship, and driver of the vehicle.
You are appearing on behalf of whom?
Owner of the temple, Lordship.
You said that you have appeared on behalf of respondent number 1 and 2.
Respondent number 1 is the owner, Lordship, and driver also. So I am
What is the name
appearing.
What is the name of respondent number 1?
Sasi Sahu.
Mr. Counsel, go through the brief first. Go through the memo of appeal.
Memo of appeal is not with me, Lordship.
Then how can you know who you are representing? Who is the respondent?
Notice is not with me. Only judgment is with me, Lordship.
Who is the respondent? The person, the cause title in the judgment is the petitioner and the opposite party, not appellant and respondent.
Yes, Lordship.
Then
Lordship may direct to the
respondent
council
number
of
1, 2, and 3. What should I
give a
direct?
copy.
Respondent number 1, 2, 3, who is appearing? Strike out the order. The whole problem.
नहीं फिर तो आज इसके तो Oh, sorry, Lordship. I am appearing on behalf of Balkumari Devi, Lordship. Balkumar, sorry, Lordship.
Are you sure now? Now you are appearing on behalf of respondent number 1.
I have stated from the judgment, Lordship, though I have not the memo of appeal, Lordship. That's why.
Who is for respondent number 2?
1, 2, and 3 are the same because they are the mother and children.
Maybe they are not same, mister.
They are minors. They are minors.
They are three different entities.
Entities are different.
This Wakalatama has been filed only behalf of Balkumari Devi.
Yes, yes.
Because the respondent number, उसमें रखिए उसको, keep that order, right? Respondent number 1 has appeared through lawyer, but no one has appeared on behalf of respondent number 2 and 3, who are the minor son and daughter of respondent number 1. Full stop. The learned counsel is Mr. Rajesh Kumar Singh, who is appearing on behalf of respondent number 1, is directed to seek instruction and appear on behalf of the minor respondent number 1 and 2. Respondent number 2 and 3. Full stop. Let's this case after 3 weeks.
Serial number 12, MA number 511 of 50, Mr. Pratish Kumar for the appellant, Mr. Nikhil Ranjan for the respondent.
But by terms of last order, 29/11/2021, Lordships was pleased to admit this case, and thereafter notice was again issued to the respondents. Perhaps Nikhil Ranjan has appeared, but this is an admitted case, but it needs to be heard. The issue is that the appellant writer is not covered in the Act only liability policy. In fact, the wife is the deceased of the wife deceased is the of the insured himself, and the son was driving the vehicle, and the claimants are the sons and daughter. So
wait for service reports.
But Nikhil Ranjan perhaps has appeared. I think.
Lordship, I appear.
Have you just a minute, Mr. Nikhil Ranjan? Have you gone through the office now?
No, Lords, we have not.
I am sitting here reading the office note, the work which should have been done by you people. And you were interrupting while I am passing the order. Look here, take down. Respondent number 1 has appeared through lawyer. Full stop. Await first receipt of service report upon respondent number 2 and 3. Full stop. Notice upon respondent number 5 in its correct and present address. Full stop. Requisites by ordinary process to be filed within 4 weeks.
But may I submit one thing, Lords?
Yes.
But as far as the respondent 2 and 3 are concerned, they are residing the same house. They are brothers and sisters. So if Nikhil Ranjan can file a wakalatnama, that would
How can you force him?
No, Lords, I can't force him. And Lords, secondly, Lords, as regards the driver is concerned, Lords, because this is the address in the records, the last resided known address. So, Lords,
I don't know.
and actually, he is also the son. He is also the son who was driving. So, okay, Lords, we'll try once.
You take appropriate steps. If you want to file any petition, you file a petition. I'll decide that.
Yes.
But I can't give you any advice and I can't file any.
No, certainly.
Yes.
Serial number 13, MA number 513 of 15, Mr. S. P. Sinha for the appellant.
My lord, order.
Yes,
Mr. Sinha. My lord, notices were issued, my lord. The office note I could not see.
The notice has been validly served upon respondent number 1. Full stop. The service report has not yet been received in relation to the notice which was issued to respondent number 2. Await receipt of service reports for 3 weeks. In this case, after 3 weeks.
Obliged, man.
Serial number 14, MA number 524 of 15, Mr. Alok Lal for the appellant, Mr. Rajesh Kumar Karan, Mr. Tarun Kumar Madho, Mr. Yogesh Modi for the respondent.
Your Lordship, in this case, in terms of order dated, last order, Your Lordship has directed us to remit the account through bank. But there was some technical glitch in remitting the account, so therefore it will take a week's time. So this may be taken up after a week or 2 weeks, Your Lordship. There was a technical glitch.
So, Mr. Alok Lal praised for 2 weeks' time in this case. We are allowed this case after 2 weeks.
Serial 15, MA number 525 of 15, Mr. Neeraj Kishore for the appellant, Ms. Pooja Kumari, Mr. Amit Kumar, Mr. Kushal Kumar, Mr. Akshay Kumar, Mr. Amit Kumar Das.
Yes, I am appealing for the appellant, Lordship. In this appeal, I have filed one IA, Lordship, that is IA number 6545 of 2018, Lordship, for condoning the delay of 29 days, Lordship. I have explained at paragraph 4, Lordship, the reason.
Have appeared. All the respondents have appeared.
I am for the respondent, Reliance General Insurance Company, Your Lordship. Insurer.
Okay. Yes. How many days delay?
29 days, Lordship. Paragraph 4, I have explained, Lordship.
IA number 6545 of 2018. This application has been filed under Section 5 of the Limitation Act, praying for condoning a delay of 29 days in filing this appeal. The counsel for the appellant submits that the appellant is aged about 62 years and after the accident was bedridden. He was undergoing treatment in a hospital and had different problems. He submits that as a result of his physical condition, he couldn't file this appeal within time. Full stop. Next para. Yes, respondent, what do you have to say?
Your Lordship, it may be condoned.
Counsel for the respondent submits that the delay may be condoned. Full stop. Considering the submission of the parties and after going through the petition, especially paragraph 4, as sufficient cause has been shown, I'm trying to allow this IA. The IA allowed delay condoned. Let's discuss under that for admission.
Much obliged.
Serial 16, MA number 530 of 15, Mr. Ashok Kumar, Mr. Kumar Gaur, Mr. Rahul Deo for the appellant, Mr. Ayush Aditya, Mr. Munna Kumar, Mr. Jagat Kumar Goswami for the respondent.
My lord, I'm appearing from the behalf of claimant appellant and claimants.
Okay.
Notices were issued.
Respondent number 2 has appeared. Full stop. So far as respondent number 1 is concerned, the notice has been validly served. Full stop. As respondent number 3 couldn't be traced, the notice was not served upon him. Full stop. Who is respondent number 3?
He's the driver of the vehicle, Suraj Kumar.
Driver of his vehicle. Are you claiming any relief against him?
No, sir.
What is this appeal for?
Appeal for future prospect, mainly 40%.
Enhancement.
Enhancement.
And it's against the insurance company.
It's against the insurance company.
Next part, since the main relief which has been sought for in this appeal is against the insurance company and not against respondent number 3, which is the owner of the which is the driver of the vehicle, I'm not directing the appellant to take any steps for service of notice, further steps for service of notice upon the aforesaid respondent. Full stop. Yes, who is appearing for the insurance company?
It's Oriental Insurance Company Limited.
The appeal is within time. There is no delay, I think.
Yes, sir. Yes, Malay.
This is an admitted case. Okay. The award has been satisfied or not?
After the appeal, with endorsement under protest, we have received it.
Place this case under the appropriate heading after 3 weeks.
Serial number 17 with serial number 18, MA number 582 of 50 with MA number 59 of 16. Mr. Chandri Mukherjee, Mr. Anjali Kumar, Mr. Pooja Kumari, as an appellant in first case, Mr. Mr. Arun Kumar Mahato, Mr. Rohan Kashyap, appellant in second case. Mr. Rohan Kashyap, Mr. A.S. Pati, respondent in first case. Mr. Anjali Kumar, respondent in second case.
Lordship, we have filed an interlocutory application, that is IA number 6563 of 2021 for extension of the agreement.
Six 563.
Yes, Lordships.
And what is the second case?
Lordship, second case, both parties have challenged the judgment here, Lordships.
There is no IA in that case.
No IA in that case.
What is the judgment?
The judgment is for remand. Yes.
Is it judgment of remand?
Yes, Lordships. It was a suit for specific performance. The appellate court, Lordships, in the judgment impugned says that as the suit land is recorded in this name of state of Bihar and it is falling under Tata lease, therefore they are necessary parties. Though, Your Lordship, it is a land which was settled by Tata, Your Lordship, and Lordships, there was an agreement between the two private parties, Tata and state, both were not necessary parties in this case.
And what is the stay?
Stay, Your Lordship, on remand, Your Lordship, the trial court will proceed, Your Lordship. There was already an interim stay restraining the trial court from proceeding further. That was extended from time to time, Your Lordships. Lastly, it was extended in 2019.
Yes, what do you have to say? Who is for the respondent?
Yes, my lord, I am appearing for the respondent.
What is the ground in your appeal?
My lord, additional.
Why have you filed an appeal?
Yes, my lord, part of the order I was agreed, part of the order The other side was aggrieved. So both of
Which
them.
part of the order you are aggrieved?
Yes, my lord, I place it. On merits, I am not fully prepared today, my lord, since this was under the heading for orders.
What is the stage now, Mr. Das?
Stage, my lord.
It was stayed, Your Lordship. It could not proceed further. There was a stay by this honorable court, which was
But
extended
even I
last
was
year.
not opposing, my lord, because I am also aggrieved by part of it. So stay was not
No,
even opposed by me.
no, just tell me.
Yes,
You are saying that it is proceeding.
yes, Lordships. I have annexed this Lordship order sheet, Annexure A, page 7, Your Lordships. The learned court below says that as the interim order stands vacated unless extended, so it has been fixed for further proceeding.
Well, some additional issues were formulated by the appellate court, and with additional issues, it was remanded back. So since the suit was dismissed, I was the defendant, so therefore I am aggrieved.
The suit was dismissed.
Yes, I was the defendant. The first appellate court remanded it with additional ground issues, framing of additional issues.
Where the state and the Tata Lease is a necessary party.
Yes.
But that is the finding of the first appellate court, my lord. At the trial stage, the suit, they were not parties before the trial court.
Yes. Are they necessary party?
But in a suit for performance, my lord, they will.
There's no privity of contract with them.
No. And my lord, in view of the recent Supreme Court judgment, the Honorable Supreme Court has specifically said that the court cannot direct any person to be added as a party. It is the dominus litis. And thereafter, in the National Commission case, also the two cases are there. In a case of National Commission, also directed issue.
Yes.
He will decide whom to proceed against.
Yes.
Yes.
Let me dispose this case next week.
As Your Lordship.
A week thereafter, kindly. Yes, my lord, on exam of 16th or 17th, if it is convenient, your lord. 14th, 15th, my lord, I have some difficulty, my lord. 16th, 17th, any day, if convenient to your lordship, my lord. Or week thereafter, my lord.
Let's this case after 2 weeks on the request of the parties so that both the appeals can be heard on merits.
In the meantime, Your Lordship, trial court may be restrained.
What will happen in the trial court?
As Your Lordship.
Obliged, my lord.
Obliged.
Come up with all those judgments.
Yes, yes, Lordships.
Under the appropriate heading.
Serial number 19, MA number 200 of 19, Mr. M.V. Lal, Mr. Rajiv Kumar Karan for the appellate, Mr. Alok Lal, Mr. Pramod Kumar Sinha for the respondent.
My lord, may I? My lord.
MA number 82 of 18, Mr. M.V. Lal, Mr. Shiv Kumar Singh for the appellate, Mr. D.C. Jha for the respondent.
Yes.
My lord, the one IA has been filed for withdrawal of the appeal number 200 of 2019, as one appeal has already been filed as MA 82 of 2018. Due to mistake, my lord, it has been.
What mistake? It has been filed from your office. You have shown the Wakalatnama in both the cases.
Yes,
you have
my lord.
filed them in both the cases. Tell me.
Yes, my lord. In fact, without verifying.
How much cost? How much cost? You have filed two appeals against the same judgment, claiming for the same relief against the same party.
Yes, my lord.
This is a double filing. Tell me, how much cost?
Uh, some cost may be imposed, my lord, as
Take down IA number 7439 of 2021. This IA has been filed, praying therein to allow the appellants to withdraw this appeal as this is a double filing of the miscellaneous appeal. Full stop. Next, para counsel for the appellant submits that challenging the said judgments already email number 82 of 2018 has been filed by the appellant, same appellants, which is still pending. He submits that due to inadvertence, this appeal has been filed uh, without verifying that for self-same relief, the same appellants have already preferred an appeal before this court, which is registered as email number 82 of 2018. He begs apology for this double filing. Full stop. Yes, Mr. Alok Lal Prabhat Kumar Sinha, what do you have to say?
Lord, apparently, my lord, against the same award, two appeals have been filed, and both the appeals have been filed from the same office. So it cannot be said that this
Mr.
is the
Prabhat
position
Kumar
of.
Sinha submits that two appeals have been filed by the same person challenging the same judgment or for same relief, and that too from the same office. Full stop. Next para. After hearing the counsel for the appellants, uh, I'm not proceeding any further. Full stop. This IA stands allowed. I am allowing this appeal being MA number 200 of 2019 is allowed to be withdrawn, but subject to payment of cost of rupees 2000 to be deposited with Advocates Association. Uh, High Court, Jharkhand High Court Advocates Association, Jharkhand High Court. Full stop. The receipt should be filed within 2 weeks. SIA allowed. 9695 also disposed of as withdrawn. Another IA, 9695 of 2019.
obliged, my lord.
Take down in the order MA 82 of 2018. Place this case under the appropriate heading after 1 week.
Under the heading for admission, serial number 21, MA number 253 of 16, Mr. Arvind Kumar Lal, for the appellant, Mr. Manish Kumar, Mr. Ajay Kumar Saab.
My lord, for the appellant, I am appealing, my lord. So this is a case of injury, my lord, and for enhancement we have come, my lord.
This is for enhancements.
Enhancement.
What is the nature of injury? LCR is here?
My lord, LCR, I am not aware, my lord, whether it has come.
LCR has not been called.
So if I have to pass a final order, then I have to go through the LCR.
Yes, my lord. Yes, my lord.
Take down. This is a case for this appeal has been filed by the claimants to enhance the amount of compensation.
My lord.
So counsel for the appellant submits that the appellant was injured in an accident and had sustained injury. Full stop. The appellant submits that as per the reports, medical reports, etc., the injury, the disability is to the extent of 40%. Full stop. He Full stop. Next para. After going through the impugned judgment, I find that it is necessary to go through the layer court records and the documents, uh, lower court records and the medical documents. Full stop. Uh, Call for the lower court records from the tribunal, consent tribunal, unless this case thereafter, under the same heading.
Online, my lord.
Serial number 22 with serial number 23, MA number 279 of 60 with MA number 639 of 60. Mr. Arvind Kumar Lal, appellant in first case, for appellant in first case, Mr. Abhijit Kumar Singh, Mr. Atanu Banerjee, appellant in second case, Mr. Saurabh Kumar, Mr. Sachin Kumar, Dr. Ashok Kumar Singh, Mr. Amit Kumar Das, respondent in first case, Mr. Arvind Kumar Lal, Mr. Kumar, Dr. Ashok Singh, Mr. Amit Kumar Das, respondent in second case.
There are two appeals in this case, my lord. In the item number 22, I am for the claimant for enhancement. I have come here, and in second case, the state of Jharkhand through deputy commissioner, they have come here. What happened, my lord? During the election duty, accident has taken place, and the election duty officer he sustained injuries and died, and the liability has been fixed upon the state of Jharkhand, and therefore let the second case be heard first, my lord. Then liability to be fixed. That whether state is liable to pay or honor or the insurance company. This is the crux of the matter. And fourth question is, my lord, whether ex gratia payment, if paid by the state 10 lakhs rupees during the if election duty person is dying in the accident, then 10 lakhs rupees has to be given. They have paid. Whether that amount is deductible or not. This is the main question they have raised in the MA 639/16, my lord. I've come here in the first case, that is for enhancement. That is in the second phase, it can be heard. First, the state argument to be heard, my lord.
Yes, who is the appellants? In next case, state. Who appears for the state?
Yeah, item number 17, Lordship.
Who appears for the state?
Item number 17, Lordship.
Item 23.
Oh, sorry.
Lordship, I am appearing for Election Commission of India. Lordship. The state have to.
Who is for the state? What is the finding on issue number 1?
Issue number 1, the parties have not placed the opposite. What happened, my lord, in this case, during the course of trial, respondent 1 to 4, that is state of Jharkhand deputy commissioner election, they have not appeared. They appeared, but they were debarred to file any written statement. The parties have not placed the opposite issue in view of the discussion made above. Claimants have valid cause of action for the suit, and the suit is maintainable in its present form. In the result, the suit is decreed in contest with cost. And therefore, my lord, issue number 1.
What was the vehicle?
Vehicle was a Magic, Tata Magic.
Insured with?
Insured with, my lord.
Reliance General Insurance Company. Your Lordship.
So this issue as to who is liable to pay, whether it is the state or the insurance company, this issue should have been decided.
My lord, there is a full bench judgment of Patna High Court, my lord, in the year 1996.
No, no. The trial court has, the tribunal has not decided this issue.
It has been decided by the tribunal, Your Lordship.
Where? I'm asking where.
It is in issue number 7 and 8. Internal page
Issue
number
number
8,
7 and
running
8?
page number 37,
Just a minute.
para
Just a
10.
minute. Issue number 7 and 8. Let us see where is the finding. Let's read that.
Para 10 onwards, Your Lordship. These issues are important in view of. Let me read the issues first, Your Lordship.
Yes, I've gone through the issue. You read from para 10.
These issues are important in view of the arguments made by the counsel of the respective parties. The learned counsel of the insurance company submits that in the present case, state is liable to pay compensation as the vehicle in question was in possession of the state for election duty. The learned counsel has cited the decision reported in 2011 for TAC 716 Jharkhand. On the contrary, the learned counsel appeared on behalf of the state submits that since the vehicle was insured and as such it was for the insurance company to pay compensation. His further contention is that claimant have already received the compensation from the state under ex gratia payment. The learned counsel appeared on behalf of the claimant, filed various decisions of different honorable high courts, out of whom some are as follows. First of all, I have pursued the aforesaid decision. The Honorable High Court of Jharkhand, in the decision reported in 2011 for TSC 716, has held thus: Constitution of India, 1950, Article 226, writ petition for compensation. Vehicle requisite uh, uh, by district administration for law and order purposes. Vehicle burned to ashes, state liable to make the payment of compensation to petitioner as vehicle in question was burned to ashes. Deputy Commissioner directed to determine amount of compensation after giving adequate opportunity to petitioner or to the legal representatives. Our own High Court has further held in decision reported in 2012 ACJ 710 damages state liability of vehicle requisite for election purposes was burned to ashes. Truck was requisitioned for electoral officer for purpose of Lok Sabha election. Vehicle was under management, control and possession of electoral officer of the state when it was burned. Whether the state is liable to pay damage or the owner of vehicle to the exclusion of insurance company, though the vehicle was insured, held yes. The Honorable High Court of Rajasthan, in decision reported in 2011 ACJ 2357, state vicarious liability. Requisition of vehicle for election duty. Truck requisitioned for election duty by government met with accident while carrying polling parties due to its rash and negligent driving resulting in death of home
Just tell
guard.
me one thing. Just tell me one thing.
Yes,
What
sir.
is your stand?
Your
What
Lordship,
is your
what is my?
What is your stand as an insurance company? Who is entitled to pay the amount?
The state is entitled to pay the award, Your Lordship.
Right.
It has been discussed here because the vehicle was for the purpose of election duty
This
under the
discussion-
control of.
This finding is under challenge.
Your Lordship, there is a judgment of 2008, Your Lordship, wherein the Honorable Apex Court has decided this issue. Your Lordship, that is
The reference.
2008 1 SSC 414, para 10 and 19 is important.
2008,
Volume 1,
Volume 1 SCC
414.
414. Yes, just read it.
Relevant paras are para 10 and 19, Your Lordship.
Yes, read that.
Para 10, Parliament either under the 1939 Act or 1988 Act did not take into consideration a situation of this nature. No doubt respondent number 3 and 4 continued to be registered owner of the vehicle despite the fact that the same was requisitioned by the district magistrate in exercise of power conferred upon him under the Representation of the People Act. A vehicle is requisitioned by the statutory authority pursuant to the provisions contained in the statute. The owner of the vehicle cannot refuse to abide by the order of requisition of the vehicle by the Deputy Commissioner. While the vehicle remains under the requisition, the owner does not exercise any control thereover. The driver may still be the employee of the owner of the vehicle, but he has to drive it as per the direction of the office of the state, who is put in charge thereof, save and accept the legal ownership of all intent and purport. The registered owner of the vehicle loses entire control thereover. He has no say as to whether the vehicle should be driven at a given point of time or not. He cannot ask the driver not to drive a vehicle on a bad road. He or the driver could not possibly say that the vehicle would not be driven in the night. The purpose for requisition is to use the vehicle for the period the vehicle remains under the control of the state and its officer. The owner is only entitled to the payment of compensation, therefore, in terms of the act, but he cannot exercise any control thereupon. In a situation of this nature, the court must proceed on the presumption of the Parliament, while enacting in 1988 Act, did not envisage such a situation. If in a given situation the statutory definitions contained in the 1988 Act cannot be given effect to in letter and spirit, the same would be understood from the common sense point of view. Thereafter, decisions has been referred, Your Lordship, in paragraph 11. However, in paragraph 19, we therefore are of opinion that the state shall be liable to pay the amount of compensation to the claimants and not the registered owner of the vehicle and consequently the appellant therein. Here, this was preferred by National Insurance Company Limited, Your Lordship, where the insurance company was held liable to pay when the vehicle was under requisition by the state for the electoral purposes.
And who died there?
Uh,
It's a case of death.
Yes, Your Lordship, it is a case of death.
Yes, I do, sir.
Just tell me one thing. Suppose a vehicle is requisitioned for 4 weeks or 6 weeks. Is there any provision, or can you say that the policy of insurance is kept in abeyance for these 4 or 6 weeks? Or the vehicle remains?
That has been decided in this case, Your Lordship. Here, a third person named Satish Kumar sustained injuries, and it has been decided that though the ownership does not change, but since it was in control of the state, and it was not the owner to decide.
I'm asking you a question. Just address this. Suppose a vehicle is insured for a period of 1 year, 365 days. Now, once an insurance policy is obtained, be it for the act-only policy or a comprehensive policy. Now, in between this term policy tenure, the vehicle is requisitioned for a period of, say, about 6 weeks by the Election Commission. Now, as per this judgment, it is quite clear, and also as per the law also it is quite clear that for this period of 6 weeks, the ownership will change. What will change is only the ownership. Is there anything to suggest that the policy of insurance will also be kept in abeyance or will lose its effectiveness for this period for the period of requisition? If not, my next question would be, there is a judgment which has come recently that even during a pendency of an insurance policy valid period, if a vehicle is transferred for third party purpose, the insurance policy will be deemed to be transferred also. Is it not? There's a judgment of the Honorable Supreme Court to this effect. So if that be so, then what will be the effect of the insurance policy during the period when the vehicle was requisitioned? Has this been answered by the Honorable Supreme Court? Was this the issue before the Honorable Supreme Court?
Yes, my lord.
Yes, my lord.
Let's read that part.
In the judgment, my lord, may I say, my lord?
Yes.
That is reported in 2014 ACJ Accident Claim Journal, page 1269. Supreme Court of India decided by quorum of honorable 3 judges, my lord.
Yes.
Devi
Yes, read
versus
that
State of
particular
Assam.
paragraph.
In this
Yes.
case, my lord, the vehicle was requisitioned for the state government, and therefore where it has been held that even if there is no permit, if the insurance is not also there, then even then state is liable to pay.
What will happen if the insurance is there?
Insurance will be kept abeyance.
It has been held.
Yes, my lord.
You read that line.
There are so many judgments of Supreme Court, my lord. ये जो है 2014 ACJ 1269, my lord.
Read that
And
part.
I will read, my lord. Just a minute. That is in para. Bus requisitioned by the state and placed on government duty. Vehicle met with an accident resulting in death of cyclist. Widow of the deceased filed claim petition under MB Act. Vehicle was not insured, and tribunal awarded compensation against the registered owner. I could held that
vehicle was not insured.
Not insured.
So,
then even then, owner is not liable.
When a vehicle is not insured, owner is liable. Owner over
Yes,
here
ma'am.
means the election commission.
Yes,
Owner
my
for
lord.
that election commission. But I am saying where there is a policy of insurance.
Yes, my lord.
Whether
The same thing I am saying. In order to assist, my lord, in case of any accident, the first liability is of the owner of the vehicle, and then insurance company comes forward to indemnify the owner of the vehicle, my lord. If owner is not liable and the vehicle is not insured, then the Supreme Court has held even then state is liable to pay.
Mr. Arvind Lal, owner is liable because the state becomes the owner for that particular period of time under which the vehicle is requisitioned.
My
owner
lord.
is absolutely liable. Owner means the definition of owner. What is an owner? Owner means the person who owns the vehicle for that time. So, by judgment of the Honorable Supreme Court, the owner for this period under which the vehicle was requisitioned is the state. So, the owner is the state. State has to pay if there is no insurance policy. Now, tell me, show me a judgment which says that the policy of insurance will be kept in abeyance. Show me that.
1997 ACJ, page 67.
ACJ, page 67.
Decided by Honorable Patna High Court, full bench.
Yes, what has been held?
In this case, my lord, just a minute, my lord. In this case, insurance company was directed to, vehicle was burnt. The insurance company was directed to assess the loss and to send the report to the state government so that the state government will pay the compensation. In spite of the insurance policy, my lord. Insurance company has not been held liable, my lord. This is the full bench judgment.
Okay, now take out the judgment, which says in respect of when a vehicle is transferred, and insurance policy will not lapse, the third party policy will continue.
My lord, before that, my lord, I will draw the kind attention of my lord. In view of section 160 of the Repenses of People's Act 1951,
yes,
vehicle is being requisitioned by the state. But the parliament has not given any finding or any clarity that what will happen during the period of requisition, whether owner is liable or insurance company is liable.
That has been answered by the Honorable Supreme Court.
Yes, ma'am.
During the period of requisition, the term owner of the vehicle will be the government or the election commission who is requisitioning the vehicle.
Then, my lord,
it is not the registered owner.
My lord, 2012 ACJ page.
My question is something else.
My lord,
what will be the effect of the insurance policy during the period which the vehicle was requisitioned? Is there any judgment on this issue? My question is this.
My lord, just a minute, my lord. The Honorable Supreme Court has held in para 13 of Punya Kala Devi judgment, my lord,
Yes.
giving reason of a definition of honor and who is the honor, in whose name vehicle is stands registered, and whether such person is a minor.
I'm not putting this question to you because this has already been answered.
My lord. Uh,
I am
Though
asking
the
you.
point was placed into service, the High Court, without adverting to Section 5 of the Assam Act, merely on the basis of definition of honor as contained in Section 230 of the 98
There
88
is
Act.
no doubt the owner will be the state or the insurance company. There is no doubt for this period,
Yes, my
which
lord.
is under requisition. The ownership will vest in the state or the or the election commission for this period of 6 months, 6 weeks or 10 weeks, which is mentioned in the notice for requisition. I am asking you what will be the status of the insurance policy.
That just yesterday I read, my lord, that
You take out the judgment, Mr. Arvind Lal.
My lord.
Read the judgment by where the Supreme Court has held that the third party insurance will be deemed to be in continuance even if the vehicle is transferred during pendency of or during
That
validity
is
of.
judgment. Yes, my lord.
Where is the judgment? You can get something from that.
Just recently, just now I am not able to answer.
Just draw an analogy. Just draw an analogy. If a vehicle is insured, now the ownership changes. Honorable Supreme Court says that third party policy will also be deemed to be transferred. Now over here, if the insurance policy is there and there is no violation of the policy, ownership changes for a limited period. Why can't it be said that for the third party insurance company has to pay? Forget who is the owner. A is the owner. Forget the state is the owner. Either A is the owner or B is the owner. What is that judgment? Who is for the state? Who is for the state?
I am for the state, Your Lordship.
What is your argument? You have to formulate your argument. Or do you accept your liability?
Your Lordship raised a very good point, Your Lordship. I have to research on that, Your Lordship.
Find it out.
Yes, Your Lordship.
Your Lordship, इन्होंने ground में भी दो लिया हुआ है. They say that since it was a but I am understanding what is calling from your
Yes, Your Lordship. One more point, Your Lordship.
Yes, yes.
During Lok Sabha elections, Your Lordship, whether the state government is the owner or the central government is the owner, Your Lordship, because it was Lok Sabha elections, Your Lordship.
Sorry.
I'm understanding the pertinent query of your Lordship. I'll find out.
Who has requisitioned the vehicle? You have requisitioned the vehicle. It is your duty to provide this logistics to the election commission. It is your duty to provide the logistics to the election commission.
What I could gather, your Lordship, whether owner is state or the center, what is my stand being an insurance company?
That is not even an issue at all.
What is
the
my
issue is what will be the status of an insurance policy during the period which the vehicle was under requisition?
Your Lordship, I'll find out.
Very important.
If for the third party purpose the insurance is deemed to be transferred for third party insurance, even when a vehicle is a new owner purchases a vehicle and gets the same registered in his name, the insurance is deemed to be valid for the remaining period for third party. Why not that analogy be applied here?
Yes, sir.
Your Lordship, I'll find out.
Yes, Your Lordship. We'll research on this point, Your Lordship.
There also the ownership only changes, that too for a limited period of time.
Yes.
In the other case, the ownership changes permanently. The Honorable Supreme Court says the insurance policy will also be transferred in his name. Third party insurance. Over here, why not? The same analogy be applied. That for this period, the insurance will also be. Insurance will indemnify the owner. Forget who happens to be the owner. Consequently, the owner will be the state. No, suppose state of the
My lord, may I say something?
Yes.
My lords, I'm nobody in this case, my lords. But just to assist your lordships, my lords, may I say something? My lords, whenever any election happens, then the government of India or the state government enters into an MOU with the insurance company for all the requisitioned vehicles. So that insurance company is always liable if anything happens during the course of election, my lords.
So he has brought in a good, a valid fact.
Let's say crores of rupees are paid to the insurance company, and the government enters into an MOU with
Then, then the government you also have to also answer if you have entered into an MOU. Have you for this vehicle? Have you raised any claims before the insurance company?
I'm not aware of
It
this.
is the government who has to answer.
Yes, my lord.
Issues are to be taken.
Because now the election in 5 states are going on. They are up to date.
Your Lordship, and there is a what Lordship has fallen from your Lordship is that the third party insurance gets transferred. Here in this case, your Lordship, one of the deceased is the patrolling magistrate, your Lordship, who was.
So what is he? He's a third party. He's a third party.
Yes, he is not the driver patrolling. Your
He's
Lordship,
not the owner. He's a third party.
He is not the owner. Yes. I'll find out, your Lordship, the specific time may kindly.
No, just tell me one thing. A vehicle belongs to a state. Now, states get the vehicle insured with an insurance company. In that case, if an accident is occurred, is state debarred from making a claim, raising a claim from the insurance company? Then to answer all these issues, because I don't think so. This answers this. This were the question before the full bench or the other bench. After the judgment of Honorable Supreme Court that the policy will be transferred, will be deemed to be transferred. There's a judgment, Mr. Lal, that the policy will be deemed to be transferred.
The deemed to be transferred, there is no such word.
No, it will be transferred. Will be transferred.
In that case, in view of the transfer of the vehicle and the insurance policy, yes, my lord. There is a judgment. Yes, yes. Just 1 or 2 months ago, the judgment has come.
Yes. Now tell me what is why the Honorable Supreme Court passed that judgment? There's a decision.
Yes, my lord. And the same analogy may be applied here, my lord.
Yes,
my lord.
If the same analogy is applied, then the
Yes,
owner
my
has
lord.
to be indemnified.
Yes.
Then the owner has to be indemnified. Now
Yes,
it has
my
to be decided who is the owner.
Yes, my lord.
Further research is required in this matter, your Lordship.
Address this issue.
Yes.
And state, you also find out whether you have entered into an MOU with the insurance companies or not.
Yes, Your Lordship. Yes, Lord.
Whether that particular insurance company is also a necessary party or not.
Yes, Lord.
So you all want time?
Yes, sir.
We get to address the issue as to whether the insurance company is entitled to, will be liable to indemnify the owner in a case where a vehicle has been requisitioned by the state and thereafter prayer has been made to adjourn this case for 3 weeks. Will be enough for you to research on this issue?
Yes.
Yes, sir.
In this case, after 3 weeks.
Oblige, your lordship.
Serial number 24, MA number 366 of 16.
Short possible Lokesh Kumar is another court, madam.
There is Rajesh Kumar also.
Short possible Lokesh Kumar.
What is this case about? Tell me.
Lordship, I am appearing on behalf of the respondent, Lordship.
Yes. Injunction refused.
Lordship, petitioner filed for challenge the order of the injunction, Lordship.
Injunction refused or injunction granted?
Lordship, Lordship, all the construction work over the land and all the apartment has sell out, Lordship.
Okay.
At the last occasion, Hujur, 7
What is
to
the
2020.
what is the status of the suit, Mr. Jha?
Suit is pending, Lordship, and 7 to 2020 Lordship. एविडेंस और प्लेंटिव पर एविडेंस के लिए था हुजूर 7 फरवरी 22 को हुजूर
For evidence of the plaintiff.
लॉर्डशिप
Mr. Indrajit Sinha. Where is Mr. Indrajit Sinha? He argued on the last date. Yes.
My lord, short possible, my lord Lukesh Kumar arguing this case.
Indrajit Sinha. Tell me, Mr. Indrajit Sinha to join. Where is? Mr. Jha, you are appearing on behalf of?
Respondent number 1 to 4, Lordship.
Where have you stated? Have you filed any affidavit?
No, Lordship. हुजूर ऑर्डर जजमेंट में भी आया हुआ हुजूर ये कोई भी किसी भी तरह का पावर ऑफ अटर्नी और कुछ नहीं जमा किए हैं जिनके कारण वहाँ इंजंक्शन इनका रिजेक्ट हुआ
Your respondent number?
1 to 4, Lordship.
Who is for 5? The construction company.
Nirmalanand Construction Company, Lordship.
And you are the landowner?
Lordship.
And you have entered into agreement with respondent number 5.
Number 5, Lordship.
And you are saying that the entire construction is over and the flats
over
are already
all the apartments in sold out.
Sold. All the apartments
Lord.
Sold.
Sold out, Lord.
Yes.
And title suit is pending, Lordship. For evidence for जो 7 फरवरी को
Pass over 1 or 2 cases. Call him.
Serial number 27, MA number 614 of 16, Mr. S.N.P. Raj, for the appellant, Mr. Kumar Sundaram, Mr. Manish Kumar, Mr. Amit Mishra, Mr. Raja Ravi Shekhar Singh, Mr. Kumar Pawan for the respondents.
I am appearing for the insurance company, Madam.
Yes. Yes, Prasad Roy, learned advocate for the appellants.
On the last date also he was absent, my lords. The time was sought by respondent number 1.
This is for enhancements.
No, my lord, claim was dismissed.
On what ground?
Because though no injury report, neither injury report nor FIR nor charge sheet or not disability certificate, any documentary evidence has not been proved.
Not been proved.
Yes.
Neither produced nor proved, my lords. Page number 4 of the internal page 4 of the award, my lords.
Which appears from page number 50, 20, 54 million, 55 million. 55, paragraph 13, bottom portion, Milord. Admittedly,
the claimants did not appear or left pursuing the case.
Claimants did not produce any documents in support of their case, my lords. If my lord will come to 54 on the top, para 8, the mentioned, on behalf of claimants, no any documentary evidence has been adduced. Even FIR was not, my lords, produced. Although I will say, my lords, FIR was there.
Owner of the vehicle appeared.
Yes, owner had appeared, my lord.
What is the stand of the owner?
Owner had stated that the vehicle was not involved in the accident. Due to collision of police with claimants, their vehicle has been dragged in the case. That is the written statement of the owner.
Okay.
And the vehicle was covered by policy, Milord. It has also come in page 13, Milord. Page 53, Milord, sorry.
Just tell me one thing. FIR was not on record.
No. No documentary, neither FIR, nor injury report, nor medical reports, neither charge sheet. Nothing has been proved.
Any reference to any case number?
No.
FIR was there, my lords. It was not produced. Raj Mahal PS case number is there, my lords. Charge sheet was also filed. I have got the copy. But the documents annexed with the memo of appeal also, my lords will see.
I'm just asking you this question because I have to understand whether this is a fake claim or there was a claim, there was a genuine accident, but the records and documents were not produced.
My lords, it is a case, my lords. Therefore, I was pointing out, my lords, it is a case where FIR is there, charge sheet is also there, driver was arrested, vehicle was, everything is there, but it is a fake claim, my lords. If my lord will see these documents along with the memo of appeal, nowhere it is mentioned that injury is due to accident. My lords will kindly come, my lords, to page number 34 for a moment. 34 एक बार देखा जाएगा, my lords. ये है, ये पुलिस भेज रहा है फॉर इंजुरी रिपोर्ट भेज रहा है. सेवा में पुलिस और नीचे राजमहल थाना, इनको रिपोर्ट भेजा गया है बाय दी माय लॉर्ड्स, दिस डॉक्टर माय लॉर्ड्स. इसके ऊपर में भी देखा जाएगा, पेज नंबर 33 में भी है, नाम लिखा हुआ सनी कुमार का, लेकिन ये कहीं नहीं लिखा कि एक्सीडेंट हुआ चाहे कुछ भी हुआ है. पेज नंबर 33. देन 34 में भी देखा जाएगा, इंजुरी दिया हुआ है, हार्ड एंड ब्लंट ऑब्जेक्ट लिखा है. ये नहीं लिखा है रोड एक्सीडेंट. डॉक्टर का ये रिपोर्ट है. देयर इज इंजुरी. वो लोग अपने थे, गिरने के बाद दे माय लॉर्ड्स केम आउट विद दिस. पुलिस के सहयोग से ये केस उन लोगों ने कर दिया. पेज नंबर 34 में देख लिया जाएगा. ऊपर का जो टेबल बना हुआ है, उसमें कॉलम जो 5th कॉलम है, किस प्रकार के अस्त्र की चोट हो सकती है, उसमें लिख दिया हार्ड एंड ब्लंट ऑब्जेक्ट. रोड एक्सीडेंट का जिक्र नहीं. देन माय लॉर्ड्स विल कम टू नेक्स्ट पेज. ये दिया हुआ है दूसरा सनी कुमार का जो भेजा है, इसमें भी कहीं नहीं लिखा कि दे आर विक्टिम ऑफ रोड एक्सीडेंट. पेज नंबर 35. ये वर्ड कहीं यूज ही नहीं किया है कि रोड एक्सीडेंट है. देन माय लॉर्ड डॉक्टर का जो एक्सरे किया है, पेज नंबर 36 में देखा जाएगा. ये डॉक्टर भी एक लिखता है हमेशा केयर ऑफ रोड एक्सीडेंट, इस टाइप का लिखता है, रीजन ऑफ माय लॉर्ड्स इंजरी, तो कहीं नहीं लिखा हुआ है. ये अकाउंट नंबर 2 का पेज 38 से सिमिलर डॉक्यूमेंट्स है, तो यहाँ लगा, वहां प्रोड्यूस नहीं किए थे।
But no one is appearing on behalf of the appellant.
I am appearing for the appellant.
Yes.
I am appearing for the appellant.
Yes. Argue.
Can you see the judgment, written judgment, Lordship?
Yes.
It has been held that the case is maintainable in budget form. Accident is also there. It must see the finding in page part number 17.
Read the finding in para number 14.
Paragraph 17 is also there, Lordship, that there is valid cause of action and claim application is maintainable in the present form. And accident is happened and it has been dashed by the truck, Lordship, in a truck.
Read para 14.
And paragraph 18 also. Paragraph 18 also.
Read para 14.
In this case, the claimant have not been able to prove the case. And here said the case is maintainable. Paragraph 17 also 18 also lost.
Maintainable is something else. If a case is maintainable, that doesn't mean that you have proved everything.
It has paragraph 18 also lost it. Paragraph 18.
So you just listen to me. You claim that you are met with an accident. You claim this. Listen to me. You claim that you have met with an accident or a motorcycle accident. So on that view, since you are claiming that, you can file a claim application.
Claim application
is when you file the claim application to show what are the materials that you have found accidents. You have met with an accident. You are entitled for compensation.
Petitioner number 2 lost. Petitioner number 2 who was also injured, who made the FIR and stated about the accident. Fact of accident.
Where is the FIR? Where is the FIR?
That is also
exhibit.
FIR lost it. FIR is there lost it.
Exhibit.
Yes.
Exhibit.
It is exhibited. Paragraph 10 has been stated loss.
Show me the exhibit.
It has been stated no document has been filed. But paragraph 10 is stated, if they have seen the paragraph 10 lawsuit, it has been seen that on the basis of the first benefit claimant number 2, case was instituted in the middle lawsuit, paragraph 10.
10, yes. Read that.
In the middle, he further deposed that on the basis of the first ban of the claimant number 2, case was instituted at Rajmal, PS, building number Rajmal, case number 15512, corresponding GR number so and so and so, again, driver of truck being number GP 13C2113. And the case is still pending.
Where is the document in support of this?
Now, also charge sheet has been submitted, it has been a stated loss. Thus, I only pray for 1 week time I received the code on the next week lawsuit because today I received the file. I have gone through this file. This has been established that FIR was launched by the claimant number 2 itself.
So what is the content of the FIR? So what is there?
I can assist next week, Lord. I can show that. I can show that.
See, suppose even if the accident had taken place,
yes,
Now this is a case of injury.
Yes.
What is the extent of injury? How much you have spent for your treatment? What are the documents?
That we have received, we have given all the documents for our treatment loss.
Where?
We have
Exhibit.
annexed all the documents of treatment.
Exhibit. This is an appeal. Where is the exhibit? Give me the exhibit number.
That I can lead the Excel evidence also here, Lordship, which has not been filed in court.
I will not allow
Because
this.
fire is there.
Additional evidence you fulfill? Rule 27, you fulfill? The conditions.
Yes,
there. If you
I pray for some time.
you want to file
File
an application
Yes.
and come within the
Yes,
purview
I filed the
of
application.
Order 41, Rule 27, then only.
Yes, I filed application, Lordship.
Request of the
3
counsel for
weeks
the
time is granted.
on the request of the counsel for the appellants, how much time?
3 weeks, Lordship.
3 weeks time is granted.
Serial 28, MA number 18, Mr. Ashutosh Anand for the appellant, Mr. Vindra Kumar.
Wait, please, Your Worship.
There is a report from BLSA.
मोबाइल को भी ऊपर नीचे कर सकते हैं। नहीं रहा इसको लग रहा है आएगा उसको वॉइस करना पड़ेगा वो अप्रूव करेगा।
Yes, Mr. Ashutosh, you are appearing on behalf of the
वर्ड कीजिएगा तब वो अप्रूव करेगा।
unmute yourself.
My lords.
Mr. Asadul, unmute yourself. Unmute. Mr. Haq, unmute yourself.
Oh, I'm sorry.
You are appearing in this case for the claimant?
Yes, ma'am.
Yes, we have taken. It has been produced the report of the DLSA Pakod, full stop. Mr. Asadul Haq, learned advocate, appears and submits that he will be representing the claimants in this case. What is this?
My lord, this appeal has been filed by the insurance company, and if my lord may kindly permit me to place it running page number 2 of the award, my lords. Internal page number 2, running page 12. The case of the deceased is the mother, and who are the claimants? The claim case has been filed by the claimant Asfarul, and other are the son, daughter-in-law, and married daughter of the deceased.
Mother,
so my lord,
mother, son.
No, son is there, daughter-in-law, that means the wife of the son, then and 3 married daughters.
Okay.
So they are the claimants.
Okay.
And para 2, that the case of the claimant in brief is contained in claim petition that claim has filed a claim petition of grant of compensation on account of death of his mother, namely so and so, who died in motor vehicle accident so and so. So this is the mother. The father had expired long back. Now, if my lord, the insurance company has filed this appeal vis-a-vis against the owner is concerned, if I may permit to place internal page number 4, para 4.
ईमेल कर दी पोस्ट किया कि सर जो है आर्गुमेंट कर रहे हैं।
I'm sorry, my lord.
The deceased was a bachelor.
No, she was a housewife, my lords.
The deceased is a.
Deceased is the housewife. Her husband had expired. The claimants are the son, बेटा है, बहू है और 3 मैरिड बेटियां हैं, 3 शादीशुदा बेटियां हैं.
Let me understand one thing. What is the name of the deceased?
I'm sorry, my lords.
What is the name of the deceased?
The name of the deceased is Bulan Beva.
पता नहीं चला ईमेल कर देखे जाता हूँ ना पता चलेगा ना.
Please unmute. No, where unnecessary noises are coming.
हैं?
Yes. Yes.
My lords, so far as the owner is concerned, my lord, our stand is, specific stand was taken that the vehicle was being plied without permit.
Mother died.
Mother died. और क्लेमेंट से बेटा, बहू और शादीशुदा बेटियां.
Okay. Okay.
My lords, so we have preferred this appeal on 2 counts against the owner because the vehicle was being plied without permit. The permit has not been brought on record, and against the vis-a-vis the quantum awarded, my lords. So I may first permitted to place my written statement, which is at internal page number 4, para 4.
Yes. Yes.
OP number 2, the insurance company appeared and filed his written statement on his behalf, entering that neither the claimant nor the owner of the vehicle filed all the required documents, and the driver of the vehicle was not holding effective driving license and authority letter to drive the vehicle, and vehicle was plying without permit, and the claimant has not produced the following documents with so and so, including permit, my lords. So vis-a-vis DL and permit, this was specific case, and if I may permit to now place depending on this issue, the issue is
yes.
at para 8.
Yes, read that.
First of all, I would like to decide issue number so and so jointly because these issues are correlated and star issues which would decide the fate of the case. It is the case of the claimant that deceased due to she died during reaction driving. Para 9, my lords, nothing. Para 10 is again the deposition, and para 11.
Yes.
From perusal of exhibit, it appears that in this reference, Pakur so and so, dated so and so, corresponding so and so against the driver of alleged vehicle bearing number so and so has been lost, and after investigation, charge sheet was submitted against the driver of the alleged vehicle, namely so and so. Further, it appears from the record that the vehicle was insured with so and so, and the alleged accident occurred on 3/14, but tribunal has to decide the case on the basis of evidence adduced before the tribunal and certified copy of the FIR charge sheet and other exhibits clearly so that deceased died in the motor vehicle accident which was being driven by the driver of the vehicle, and there is no evidence on behalf of the insurance company that the driver of the vehicle was driving the said vehicle rationally and negligently. In this circumstance, I find the accident has not taken place due to rational negligent driving of the driver. OP number 2, the insurance company has not got examined any witness to prove that due to rash and negligent driving by the driver of the operating vehicle, accident took place, and I find that accident has not taken place due to rash and negligent driving of the driver. It is true that the vehicle was duly insured at the time of accident, registered in the name of the owner of the vehicle, and the driver had valid driving license, and driver had not violated the terms and conditions of the insurance policy, and the insurance company has not been able to show that the owner of the vehicle had violated the terms and conditions of the policy for which the vehicle has been insured under the insurer, and the insurer of the vehicle is liable to pay compensation to the claimants for the death of the deceased who died in the accident. Hence, I come to right conclusion that the insurance company is liable to pay compensation to the claimant.
Yes.
My lord, the owner had appeared, my lords, and he had not produced the permit documents, my lord. In para 3, my lord, his written statement is there. He only testified against with respect to the driving license. So, my lord, in view of the fact that the permit has not been produced by the owner, hence the insurance company would at the best be entitled to a right of recovery, my lords, at present.
Yes.
My lord. So far as quantum is concerned, it was the case of the claimant that the deceased was earning rupees 9,000 per month by doing tailoring work. Now I may permit to place the relevant aspect regard to that. If your lordship would kindly turn to internal page number 6, para 9. May I be permitted to place the same?
Yes.
He has just in the middle of para 9.
Yes.
He has further deposed that Bulan Beva was a housewife and working as tailoring, and she used to earn rupees 9,000 per month. In his cross-examination, he has deposed that police has not recorded his statement regarding the accident, and he has seen the accident, and he has also seen that Bulan Beva was working as tailor. Yes.
Yes.
He has again stated that he does not know the name of the owner of the offending vehicle, nor he knows the number of the tailor.
What is the evidence? NCR. Who is the owner of the vehicle? Who is the owner of the vehicle? Anyone appearing on behalf of the owner of the vehicle? Was this son and daughter were dependent on this deceased? Any evidence to that effect? Son, daughter, daughter-in-law were dependent upon the deceased. Yes, Mr. Ashutosh Anand. Mr. Manoj Sinha. Mr. Manoj Sinha. Mr. Manoj Sinha. Where is Mr. Manoj Sinha? Who has been connected with the ID of Mr. Manoj Sinha? I'll initiate a contempt. Mr. Manish Kumar, Mr. Ashutosh Anand, please switch on.
My lords.
This entire proceeding is recorded because
My
it is
lord.
a live streaming. I'll initiate a contempt against Mr. Manoj Sinha, who is him. And it will be very difficult for him to disprove what he has done. He's roaming around in the open, in the trees, in some park or somewhere, entering in the court proceedings. What is this?
It is mentioned in the list also that lawyers should appear in proper dress from proper place, my lords. It is mentioned in the list also now. Earlier it was not there. Now it is been mentioned also. Not proper, my lords.
Connect the president of the bar and the chairman bar council. Correct. Yes, sir. Now, is there any evidence? I'm asking Mr. Arshadul Haq, Mr. Ashutosh Anand. In this case, is there any evidence to suggest that the claimant, that is the son of the deceased, the daughter-in-law of the deceased, the daughters of the deceased, married daughter of the deceased, were dependent upon the deceased? Is there any evidence? I'm asking you. Unmute yourself, Mr. Ashutosh Anand. Mr. Ashutosh Anand. Mr. Ashutosh Anand, please
My
unmute
lord, my
yourself.
lord.
And join, yes. Is there any
My lord,
evidence?
am I audible, my lord?
Yes, yes, yes. Is there any other evidence?
My lord, there is no such evidence that the son or the daughter-in-law or the married daughters were in the exclusive dependency of the deceased housewife, deceased mother. There is no such evidence.
So, what is the analogy? What is the rationale?
My lord, the normal person, the normal.
What is the rationale? If a bachelor dies, 50% has to be deducted. So in this case, if a lady was earning something and all the other were not dependent on her earning, why not the same analogy be applied? You develop this. Unmute yourself, Mr. Ashutosh Anand, every time.
I'm sorry, my lord. I'm sorry, my lord.
You develop on this. I want to go through the LCR also.
My lord.
Mr. Where is the president of the bar?
Your Lordship.
Madam, there is a notice, and it is a decorum also and prudence also, that if a person is appearing before this court, or if he is logged in, he should be from a proper place in a proper dress. This proceeding is being live streamed. You go through this proceeding, the live streaming, and seeing a lawyer who is strolling around in a park or beneath a tree, and he's entering in the proceedings. He's entering in the court. Your presence means that you are present in the court.
Yes,
Whether you are addressing the court, you are not addressing the court, it's not a matter which is to be looked into. Mr. Rajendra Krishna, Chairman of the Bar, Bar Council. When you are logging in, that means you are in a courtroom.
Yes, please.
Whether you are addressing, whether you have a case or not, it's immaterial.
Yes, please. Once I logged in, I am in the courtroom.
Yes. The hearing is only by the virtual mode, but it will be deemed that you are in the court.
My lords, it is correct.
And there is a notice that the lawyer should log in or appear from a particular in a proper place and a proper dress.
Yes, please. That is also there.
This proceeding is live streamed. The streaming is there in the YouTube. Check the proceeding and find out a lawyer was logged in when he was strolling in a park, or he was strolling in the road, or he was beneath the tree. Do you want me to initiate a contempt, or you yourself will take an action? Just tell me. I've called you for this purpose. Everything is recorded. Everything is recorded.
My lords, my submission before my lord is, my lord, say if suppose some lawyers are not aware, my lords, for the reason, my lords, they might not have gone through, they can be excused, my lord, for that for the present.
I am telling you, if you will take an appropriate action, or I will initiate.
I will, my lords, I will also.
Take it. Do whatever you like. Go through the proceedings.
My lords.
But
henceforth,
if a person is not aware, make them aware.
Yes, lords, I will. That is the reason, lords. That is I'm telling, lords. Let me, lords. Let us all, lords, circulate the notice to all the lawyers that they should aware about it.
It is printed in the list. It's deemed to be circulated.
Lords, sometimes, lords.
Can you, Mr. Rajendra Krishna?
Lords, I understand.
Can you tell me that I am ignorant of this amendment of law?
No.
Published in the Gazette.
But lords, to make sure that lords they have gone through it, lords, just to
do
make
sure. You do. I'm throwing the ball in your court. I'm throwing the ball in your court.
Lords, some time, lords. It is, lords, give us some time, lords. In the meantime, I think the President Association, Advocates Association is there. Lords, she will also. We both.
From your submission, I get that you want to handle the issue. You handle the issue.
Hujur, हम कब से aware तो करा दे सकते.
I'm not doing anything.
Lords, my. No, Lords, we should combinedly handle the issue. Lords, my submission.
I am not doing anything. I'm not getting involved in this issue. Since you said that you will look after it.
Lords, my submission, Lord, is that, Lords, let us, Lords, we will. It's a combined effort, Lords, and I assure this honorable court that lawyers henceforth will not.
So if you are assuring that then it means that I am not to take any action. So I'm not
मुझे
taking
हमको
any
थोड़ा सा वक्त दे दिया जाए, हम तब तक इन लोग को तब तक मिलर्स द प्रेसिडेंट से
You said that he will look into the issue. You do whatever you like. I am not stating that you have to do in a particular manner or you have to do X, Y, Z. You do whatever you want to do.
मिलर्स Milots is throwing the entire responsibility on my head.
Definitely, you are the bar counsel.
Milots, I will accept, Milots. I will accept. But Milots,
it should be upon you to educate, to make them realize it's up to you. It's you. It's a bar counsel.
Milots, we will take steps.
Yes. Thank you. Next.
Oblige.
Call for the low court records in this case.
Serial 29, MA number 474 of 17, Mr. Ramchandra Sahu for the appellant, Mr. Ashutosh Anand for the respondent.
Yes, Mr. Sahu.
Lordship, appeal has been preferred for enhancement of compensation. Lordship.
Yes.
In this case, Lordship, future prospects has not been calculated in our Lordship, and only 20,000 have been given, my Lord, in conventional head.
This is the only ground which you are taking.
No, Lordship, one more ground, Lordship. Exhibit 1, Lordship, that is salary certificate of the DG Dhiren Mahato.
Yes.
That has not been considered by the tribunal, Lordship, and income has wrongly been assessed by the court below, Lordship.
Yes.
इसमें पैराग्राफ 8 देखा जाए तो लॉर्डशिप फाइंडिंग जजमेंट का पेज 4 में है, ये सैलरी सर्टिफिकेट प्रूव
Let us take up. Let us hear this. Yes. So 3 issues. Mr. Ashutosh Anand, issue number 1, future prospect not considered.
My lord, that I cannot say anything about that.
Of the award itself.
My lord.
On conventional head, only 20,000.
My lord,
That is also on the award. So the third point which needs consideration is which you have to assess the income. Let us see.
My lord.
What is the evidence? Yes, Mr. Saab. Come to the evidence. Read PW1. There is some problem with your connectivity, Mr. Sahu. Where is evidence of PW1? Yes, Bimla Devi. Mr. Sahu, I think it will be better if you log out and then again log in. Yes, Mr. Sahu.
the
उनतीस नंबर
What is Exhibit 1, Mr. Sawa?
that is a
Yes, Mr. Ashutosh, what do you have to say?
My lords, I'm permitted to just place 3 paragraphs from the impugned judgment, my lords.
Yes.
Paragraph number 7 at page number 4.
7. Page number 4. Yes.
Para 7, just last line of the para 7. However, she has admitted.
Read the entire paragraph.
On perusal of oral evidence, I find that PW1 Vimla Devi, the plaintiff number 1, herself has stated that her husband Dhiren Mehta died on so-and-so at so-and-so in a road accident at so-and-so. She has further stated that she heard that a pickup van bearing so-and-so being driven by its driver rashly and negligently dashed behind a dumper. As a result, her husband died. She has further stated that her husband was working as a lineman and was earning a sum of rupees 300 per day. In a cross-examination, she has stated that she has not seen the occurrence. However, she has admitted that there is no any document regarding the income and age of her husband. So she admits that there is no document of her income. Now, PW2, Bhaskar Mehto. He has stated that he knew Dhiren Mehto, who died in a road accident on so-and-so. He has further stated that he, along with Karthik Mehto, both jointly run a business under so-and-so business samiti. And after fishing from the river Damodar, fishes were brought at Dumaria, Arhat, and sent the fishes to Balughat so-and-so. He has further stated that Dhiren Mehta was working as lineman and he has gone to Balughat, South so-and-so, daily for loading the fishes on pickup van number so-and-so from Dumaria, Arhat, for which he had got a sum of 300 per day. He has proved the salary certificate issued on 12/11/2013 marked as Exhibit 1. In his cross-examination, he has stated that he has no any document regarding the business of fishes and he has not paid income tax or sales tax and there is no registration for his business. He has further stated that he has not prepared any paper about the workers. I'll stop for a moment, Your Lordship. The salary certificate is issued on 12/11/2013 and the death is on 24/6/2013. So this document is post the death of the deceased.
For this post, Exhibit
My lord.
1?
Is post.
Post death.
My lords.
Okay.
Now, the tribunal has dealt the same while deciding issue number 6 at paragraph number 13.
Yes, read it.
The plaintiff's claimant have claimed that the deceased was a fish transporting lineman and was earning a sum of 300 per day, and this fact has been supported by the witnesses. However, the plaintiff's claimants have filed income certificate of the deceased Exhibit 1 to show that his income was 300 per day by working as a fish transportation lineman. But PW2 Bhaskar Mehta in his cross-examination has stated that he has no any document regarding the business of fishes and he has not paid income tax or sales tax and there is no registration for his business. He has further stated that he has no any document to show that the deceased Dhiren Mehta was permanent worker. Similarly, PW1 Vimla Devi has admitted in a cross-examination that there is no any document regarding the income and age of her husband deceased. So, in my opinion, it is clear that the salary certificate of the deceased so-and-so is not genuine. Rather, the same has been brought for getting highly and excessive compensation from the defendants. As such, it is crystal clear that the deceased so-and-so was only a daily wage laborer. However, at the same time, nowadays, even an unskilled daily wage labor gets more than rupees 100 per day. And in that view of the matter, the per day income of the deceased cannot be assessed less than rupees 100 per day. Therefore, if per day income of deceased is assessed at rupees 3,100, which appears...
Just listen to me. The court has held that even the daily wages employee get more than 100 rupees per day. So what would be the minimum wages? It is not a case that he was unemployed. So what is the minimum wages?
My lord, that I haven't checked. To 2013 में तो minimum wage my lord से एक बार देखेंगे.
Yes, Mr. Sahu? What is the minimum wages in state of Jharkhand in 2013? Yes, Mr. Sahu. Where is Mr. Ramchandra Sahu? Mr. Sahu? What was the compensation which was assessed?
My lord, the compensation has been assessed at rupees 3,56,000.
Lakhs.
My lord, I just browsed through the online, my lord. I found that minimum wages was rupees 127 for unskilled labor.
And semi-skilled?
My lord. 130.69. I'm talking about 2013, my lords.
Yes, it should be.
My lord.
It should be 2013.
My lords. Perhaps Mr. Sahu's connection is not static.
Yes. Yes, there's some problem with Mr. Sahu's connection. So, Mr. Ashutosh Anand, what do you think?
My lord.
This 100 rupees has been correctly assessed?
My lord.
Or not?
Own limitations in live streaming process, my lords.
As a officer of the court, if I ask you,
My lords, I may be excused to answer this question, my lords.
you have to answer.
Now, the tribunal has considered the deceased to be unskilled laborer, my lords. So, in numerous cases, the lordship has taken the taken recourse to the Minimum Wages Act, my lords. So,
Unskilled laborer, it comes to 125.
127, my lords.
127. And semi-skilled, it's
130.69.
130. 127. So, what will be the monthly? 127 into 30?
My lord, into 26, my lords, perhaps.
26 will be 30. These people work overtime also.
My lords.
The second shift, they also work. A person.
My lord, 3,780 for 30.
So where is Mr. Sahu? Yes, Mr. Sahu. Has your connection stabilized? There's some problem with this connection.
My lords.
However, let's see. Let me take up another matter.
My lords.
Yes, next. Next.
Serial number 30, MA number 132 of 80, Mr. Praveen Akhoi for the appellant, Mr. Atanu Banerjee for the respondent.
My lords, in this case, I will appear on behalf of the appellant and will file wakalatnama, my lords. So I was seeking, praying for some time, my lords. 2 weeks time may be granted to me.
Serial number 30.
Yes, my lords.
What is it? Let's see.
It is probably a proceeding, a probate case proceeding, my lord.
So let us see. Probate was granted or dismissed?
Lords, I don't have the brief, my lords. Only telephonic conversation between me and my client, my lords. He has gone to Pune for examination of his son. So he'll be coming. My lords, the appellant Narendra Mahato.
Praveen Akhori.
So Praveen Akhori was earlier appearing, but now he is a state counsel, and probably in this case the state was party, so he cannot appear in this case.
State was a party.
Yes, my lords. In probate proceedings, normally state is made party, my lord.
That
Though
is a
formal. Yes.
formal party. Take down. Mr. Pradeep Kumar Devmani, learned advocate, submits that he has received instruction to appear in this case on behalf of the appellant. He submits that he will file an wakalatnama by next week. Unmute yourself, Mr. Devmani.
My lord, 2 weeks time may kindly be granted.
By 2 weeks. Full stop. Next para. Prayer allowed. Place this case after 2 weeks. Full stop. In the meantime, let the lower court records be called for so that be called for.
Much obliged, lord.
Next.
Serial number 31, MA number 159 of 18.
May I please, Your Lordships? Lordship heard this matter on 29th of September 2021. Notices were issued and the lower court record was called for. Lordship, we had filed the notices within time, Your Lordship, but it appears nobody has appeared. Lordship, the case is where...
1, 2, and 3.
Yes, Lordship.
None appears.
No one has appeared.
No one has appeared.
So, Your Lordship, respondent number 1 and 3 had supported me before in the trial court. Respondent 2 contested it.
The court has held.
Lordship, court has dismissed my application for grant of probate.
On what ground?
It was a registered will on the grounds that one of the witnesses said, Your Lordship, that the will was read by the executor himself before signing, and the other witness said that the advocate explained him the contents of the will. That is the contradiction as per the court, on the ground of which it is. The mother of the executor, that is my mother also, she has supported, my sisters have supported the execution.
Who is opposing?
One of my brother is opposing.
This appeal will be heard. Admit. Issue notice after admission upon Respondent number 1, 2, and 3. Registered ordinary. Requisites 3 weeks.
Obliged, your lordships.
Call for the original lower court records.
That has already been called for, most probably.
Lower court record is here.
Obliged, your lordships.
Yes, next.
Serial number 32, MA number 216 of 18. Mr. Satish Kumar Uggal, Mr. P. Sudham, Mr. Tapas Kabira, for the appellate.
My lord, I am appearing on behalf of the appellant.
Yes.
Satish Sugal is not available in Tapas. I am assisting Tapas Kaviras. Sir, this misappeal has been preferred against the order dated 21/2/2008 passed by the London Lower Court in probate case number 1214. The probate is allowed. In brief of the case is the will dated 1/4/2009, registered on 8/4/2009, executed by late Pushpavati Devi in favor of respondent number 2, Shanti Devi, with respect to the residential house premises recorded under Khata number 727, plot number 3185 of Mauja Mango, Jamshedpur district, Islamabad. The London Lower Court has held that the will has correctly executed and therefore probate has been granted because the will was made by the testator with sound mind and health. This is what the findings of the lower courts. My respectful submission for this one, your own lordship, is the signature of the testator has not been proved, and the signature of the one of the attested witness has also not been proved. The contents of the will has not been explained as admitted by the PW1. A record from the registrar has not been called for to substantiate the signature of the testator. Sorry for it.
Yes. Let me go through the findings. Go through the findings.
The London Lower Court in para page number 30. Five issues has been framed in London Lower Court. In page number 31, page 3 of the Limpung order, 6 issues has been framed.
Yes.
And it has been settled 5 issues interconnected with each other.
What is the relation?
Lord,
What is your relationship with the deceased?
my mother.
Your
I
mother.
am residing in the same house.
Your mother.
Yes.
And the will is in favor of the will is in favor of
my brother's wife.
Brother's wife.
She is also residing in the same house. And I am maintaining the entire family. And the will was executed in 1st April 2009. It was registered on 8/4/2009. My mother expired on 16/3/2011. So my mother was residing with me, but she never disclosed about the said will. She was 80 years old, and her mind was also not sound. And the will has been executed by my brother's wife, that is Santi Devi, respondent number 1, collusively suppressing the facts, and therefore the will has not been executed in
You have not filed
sound
any.
mind.
You have not filed any written statement before the court below.
I filed.
You have filed or you have not filed.
Filed. It has been mentioned in the order also.
Come to the order sheet.
In para.
Read para 3. Read para 3.
Returns were not filed in this case, and defendants were debarred for filing return by order dated 15. So many defendants were there. They have not filed, but I have filed the so cause, which was treated as written statement. I have filed no objection, which was treated as written statement. In para 4, it is mentioned, contest defendant number 2, Madan Kumar Sahu, appeared before the court and cross-examined the plaintiff's witness as well as produced evidence in his favor.
Who is Saroj Devi? PW2?
Saroj Devi is one of the attesting witness. My sister.
Your
married sister.
Another attesting witness is husband of
Saroj Devi.
Saroj Devi.
He has not been examined.
Is it necessary to examine all the attesting witnesses?
That is not necessary, but his signature at least ought to have been proved.
It is not necessary. It's not necessary.
Anyway, the signature of testator ought to have been proved, which has not been proved.
PW number 3 is your husband. Is the husband of the.
No, see the.
Which PW3?
PW3 the Devar. Vinod Kumar Sahu.
Notice to respondent number 1, registered both process, requisites 2 weeks, full stop. In the meantime, call for the lower court records.
Serial number 33, MA number 247 of 18, Mr. P.C. Sinha for the appellant, Mr. Manish Kumar, for respondent.
Yes, Lordship, I am appearing for the appellant. This is for the enhancement of the compensated amount, Lordship. I have been given only 2,54,494. That is apparent from internal page number 9.
9.
Yes, Lordship, he has calculated. एक चार्ट है उधर बीच में मेडिकल एक्सपेंसेस में 29,000 दिए हैं पेन एंड सफरिंग के लिए 1.5 लाख रुपया है फ्यूचर मेडिकल एक्सपेंसेस के लिए 75,000 है 2,54,994 रुपया है
What is the nature of accident?
Yes, Lordship. That is a permanent, Lordship. Both legs, one leg amputated, Lordship, and 70% disability, permanent. He was the driver going to Haryana from Calcutta near Bari. In one accident, this occurrence has taken place on 2nd March 2007.
Who is appearing?
I am appearing, my lords.
Yes.
The issue of, my lords, the claimant being a driver, my lords, is seriously, my lords, I am raising objection because he has produced one driving license which has been marked as Exhibit 4, that is for driving LMV professional. No doubt it is there, my lords. He is claiming that at the time of accident he was driving at a heavy vehicle, my lords. So that story is not made up, my lords, along with this, does not match up with the, my lords, driving license of the claimant, my lords. No doubt there is a driving license, but he has failed to establish that whether he was employed at the time of accident or not. No doubt, my lords, no amount under the pecuniary head has been granted, my lord, that is error on part of the tribunal. Accident is of 2007.
He was a driver.
He has produced one driving license
A driver who is having
shows that he was having a driving license.
Be it for LMV or HMV, it's immaterial. Now, if one of his leg gets amputated, what is the extent of
that
damage?
Will be, my lord,
will you keep a driver?
That will be 100.
Will you keep a driver drive your personal vehicle whose one leg is amputated? Will he be in a position to do the drive?
No, that will be. I am not disputing that, my lord. I am saying that they have set up a case that he was a driver of heavy vehicle.
It's a heavy vehicle. I am taking it to be a LMV. So,
and he has evidence to the effect that whether he was employed on the date of accident or not. Therefore, I am saying that notional income should be taken.
It is only not a question of employment. It is a question of his future employment also.
Yes. No doubt it will be treated as 100% disability
100%,
because
100% functional disability.
Yes.
For calculating 100% functional disability, what would be the income?
Yes. That is the only thing, my lord, because nothing has been awarded.
Income was considered, Lordship, only 5,000.
5,000 per month.
No, that was claimed. Not considered. The learned tribunal has not believed that he was employed.
Not even considered. The learned tribunal has not even considered.
Yes.
That is.
2007 का accident है.
2007 accident. So, admittedly, there is a 100% scope of enhancement.
Yes.
Where is the lower court records?
That was called for, my lords.
Let us see what is the evidence, Mr. Manish Kumar. Yes, Mr. Sinha, what is the evidence you have led so far as income is concerned? And what is the injury? Let us see.
It was stated by Lordship, this injured that his income was 5,000 Lordship. So,
Let us
Lordship, may I?
the evidence. Let us see the evidence.
In the claim petition, Lordship, it was written, Lordship. So Lordship, para 2 is somehow important, Lordship, that I want to place, Lordship. He was driver of truck number so and so coming from Calcutta to Haryana, and said vehicle was parked nearby one hotel, Lordship, at Barhi. Further stated that the passing GT, suddenly a trailer being driven by the driver asleep negligently, so received grievous injury on both legs. Thereafter, immediately injured was taken to the doctor state dispensary for treatment, from where he get more better treatment, got himself admitted GM nursing home.
Read the FIR. Read the FIR. Read the FIR, because in paragraph 4, this you were returning along with the truck.
FIR हम क्लेम पिटीशन पढ़ रहे हैं हुजूर.
No, I am asking you, when the accident had taken place, you were returning with your truck.
Yes, my lord.
Yes, Lord. Sir.
You were driving the truck.
He was the driver of the truck.
And another vehicle had dashed against the same.
No, yes, Lord. Sir. Trailer dashed. As this petitioner was, this claimant was crossing the road for natural call. And the trailer came and dashed him. That is the case. He was standing near one hotel at Barhi, Lordship, name has been given. Both legs, Lordship, damaged, and one leg was amputated, that is right leg.
Mr. Manish Kumar.
My lord.
The Exhibit 3 series is the disability certificate. His right leg is amputed from
yes,
the knee.
I am not disputing that. I am not disputing that.
So if that be, just a minute.
And he was treated up to Patna, Lordship. He was in the hospital for 1 month, more than 1 month.
Have you got the driving license? Do you have, Mr. Manish Kumar, are you having,
yes.
Are you having exhibit, driving license is exhibit?
Yes, sir. 4, just a moment.
Just come to the next.
Driving license is, my lords, just a moment.
Come to page 9 of the driving license.
Yes, exhibit
4.
Come to page 9 of that exhibit 4.
Yes, my lord, yes.
What is the endorsement of licensing authority Kodarma? He is allowed to drive HMV.
Yes, from 9/5/2006. Yes, my lord.
Then,
yes.
Then
I stand corrected, my lords. I had only seen that LND. Page number 5 and my lords, this 7.
I'm not blaming you, Mr.
Yes, my lord.
And you are not that of a person that will mislead. I also know that.
My lord.
Happens. So now 5,000 rupees is bare minimum.
Yes, my lord.
Driver. So
5,000, my lord, it has to
calculate and send a calculation to me. Calculate and send the calculation. Give the calculation to Mr. Prabhas Sinha.
My lords.
Keeping it day after tomorrow for orders.
Yes, my lord. Yes.
And so far as future medical expenses, it's, I think it
My
should
lord,
be
in the case of amputation, my lords, in absence of any evidence for future medical treatment that has been rightly given, my lords, there should be some amount should be given for, my lords, loss of amenities of life.
Yes,
And my
yes.
but so far as future medical treatment, in the case of amputation, my lords, no future.
Loss of amenities, some amount has to be granted.
Yes, my lords.
And you calculate the amount on 5,000 rupees.
Yes, my lord.
And considering future prospect also.
Yes, yes, it has to be considered, my lord.
Yes. Day after tomorrow under the hearing for orders.
My lord. Obliged.
Yes, pass over.
Pass over cases. Serial number 24, MA number 366 of 16. Mr. Mukesh Kumar, Mr. Rajesh Kumar, for the appellant, Mr. Santosh Kumar Jha, Mr. Bhavik Prasad Sinha for the respondent.
Yes, Mr. Lukesh Kumar. What is Mr. Lukesh Kumar? Mr. Indrajit Sinha is also here in this case. On the last date, he also appeared. Where is Mr. Indrajit Sinha? Connect Mr. Indrajit Sinha also. Take down. On the first round, when this appeal was called to be heard, a prayer was made on behalf of the appellant to adjourn to pass over this case for few cases, on the ground that the counsel, Mr. Lukesh Kumar, is busy in some other court. Full stop. When the case was called out thereafter at 1:20 p.m., no one appears on behalf of the appellant. Full stop. Next line, considering the aforesaid fact, list this case after 8 weeks. Full stop. It is made clear that there is no interim order passed in this appeal. Let a copy of this order be forwarded to the court concerned.
Serial number 29, MA number 474 of 17, Mr. Ramchandra Sahu, Mr. for the appellant, Mr. Ashutosh Anand for the respondent.
That is Mr. Sahu. Yes, Mr. Sahu. There's still connectivity problem from your end. Either. After hearing Mr. Ramchandra Sahu and Mr. Ashutosh Anand, the learned advocates, some issues in respect of internet connectivity cropped up from the side of Mr. Ramchandra Sahu. Full stop. List this case after 1 week. Yes. Yes, the next 215. 215 is a different bench. 215 is a different bench. Thank you.
Your Lordship, one matter at serial number 37, Your Lordship, it is for stay, although it is coming in admission for some reason, Your Lordship, it is at serial number 35 on behalf of insurance company, appellant, my Lord.
It's for admin.
I mentioned,
We'll see whether any case is made out or not.
my Lord, actually, lower court has proceeded in execution proceeding, my Lord. We are willing to deposit the amount before this honorable court, my Lord.
At the stage. Show me, give me the serial number.
My Lord, 35, my Lord.
What is the ground?
The major, most important ground is, my Lord, are two. Firstly, my Lord, as per the claimants, the deceased was a khalasi, and the insurance policy in the insurance policy there was no coverage for khalasi.
List this case on Friday under the heading for orders for considering IA number so and so.
Obliged, my Lord. Deeply obliged.
But see, one personal matter is serial number 24. I could not appear.
Well, nothing remains in this case.
So far, the matter is concerned, the construction is complete. I have given the entire detail.
They have stated that the construction is complete and the flats have also been handed over to the respective purchaser.
Flats have not been handed over. Now the sale is going on, Lordship. That is there. It is not as such a sale has been completed. And it is a report of it is a report which has come annexure 4. I have annexed, Lordship. The report says कि 5 कट्ठा में सिर्फ एक ही कट्ठा मेरा बचा है, बाकी सब चला गया उसमें.
There's not a case of your prayer was to
for injunction, Lordship.
For injunction, what construction is complete.
At that time the construction was going on.
Finished. Then
any observation to कुछ complete करने के लिए time frame कर देते हो.
So you want to withdraw this?
In that case, I will withdraw also.
काटिए, लिखिए. Mr. Lukesh Kumar, लिखिए. When the matter was heard, Mr. Jha, what is his full name?
Santosh Kumar Jha.
Mr. Santosh Kumar Jha, appearing on behalf of respondent number 1 to 5.
1 to 4.
1 to 4 submitted that the entire construction has been completed. He submits that an injunction was prayed for, praying therein to injunct these respondent, respondent and other to stop the construction and injunct them from not constructing any further, constructing the building any further. He submits that he submits an instruction that the entire construction has been completed. Also, next paragraph. Mr. Lukesh Kumar submits that is from instruction submits that the construction admits that the construction has been completed. Next paragraph. This application under order 13 next paragraph. The application under order 39 rule 1 and 2 was filed. Praying therein
Page 3.
praying therein to restrain the defendant from carrying out any further construction over the land, which is the subject matter of the suit. Full stop. Next paragraph. Since the construction has already been completed, I find that this appeal is rendered infructuous. Full stop. Thus, this appeal is dismissed as infructuous. Uh, the trial court is requested to take up, to conclude the title suit number
39 of 2015.
2015 at the earliest, and dispose and pass a judgment and pass the judgment without any delay. Thank you.